The Home Mortgage Law Show is a paid program and is intended as a resource guide for education, information, and entertainment purposes and is not intended to provide specific legal advice. The information that you hear should not be used as a substitute for competent legal advice from a professional attorney. Hiring of an attorney is an important decision which should not be based on advertising or the information that you hear today.
You're listening to the Home Mortgage Law Show, brought to you by the law offices of Morris DuPont. Attorneys Will Morris, Shay DuPont, and Michelle Hanash, our bankruptcy attorney, here for you as we are every Saturday afternoon. The number to call the studio, 866-610-NEWS. It's toll free, 866-610-6397. AT&T Wireless customers, star 610. Let's hit the phones with Mike. Hi, Mike.
Mike?
Hi. Thank you for taking my call.
Sure. What can we do for you today?
I have currently on my primary house, I was just refinancing through the same company. I've been with Citibank for probably about 15 years, maybe more.
Okay.
And I have a first and second on the house. The second is with Wells Fargo.
All right.
About 7 years ago, I refinanced to take advantage of what was then low rates.
Mm-hmm.
And
What was that, 6%?
5 point something.
Yeah,
Mhm.
okay.
And you're pretty close. And what happened was, I'm finding out now, we went through the loan process. We were just about at closing. And come to find out that back 7 years ago, when I refinanced, Citibank kind of missed something, and the primary loan
Yeah.
became the secondary.
Happens all the
And the
time, right?
secondary became the first.
Right.
Okay, so now when I go to refinance, I'm almost all the way through with Citibank again, and to take advantage of the new low rates. And now they're telling me they do not write anything on seconds, that unless Wells Fargo gives up their first position,
Right.
they cannot help me out. Now, this is after going through the whole loan process,
Sure.
and paying the fees and whatnot.
And Wells Fargo is not going to agree to take second position
Right.
now once they
Wells
learn they're in
Fargo,
first position.
That's correct. They kind of laughed at it.
Of course. Why would they give it up now?
Do you have positive equity in the property?
Yes, I do.
Okay.
What was the amounts of that first mortgage before you refinanced it?
The first mortgage was
Or is?
somewhere. Well, currently I have about I guess about 75 on one and 55 on what was the second.
Mm-hmm.
But when you refinanced it, did you just lower the interest rate, or did they increase the balance of your mortgage?
The only thing we put in there was the closing.
Okay, because from a legal standpoint, if your first mortgage is refinanced and the second lender has notice, obviously, of your first mortgage, that portion of that first mortgage retains its first priority.
Right. To the extent it paid off the first.
Exactly.
Right.
You know, I don't know, practically speaking, you know, the implications of that to try and get your lender to work with you, but it's not all is a lost cause. That's the reason why there's the public records to put other lenders on notice.
Right.
And sometimes mistakes do happen in these situations, and there may be recourse for you to get that addressed.
So the title company should have maybe had maybe something slipped through the cracks with the title company. Is that what you're saying?
I don't know where the problem
Right.
lies.
There's definitely a problem. It could be at several different places. It could be the title company. It could be, somebody not recording the new mortgage in the right way. It could be
Right.
a lot of things, right?
The recording
Yeah.
situation. So definitely problem. What's the current market value of the property?
Not much more than we owe. I think we have, let's see, something about 130. I think the value is maybe about $25,000 more than what I owe on it.
Okay.
What are you thinking, Sheriff? Having just refinanced them both?
No,
Well, I would like to, but that falls short of another problem here, is that the 80% rule.
Mm-hmm.
And we would actually end up a little bit upside down on that.
Right.
Yeah.
And
Yeah.
if you want to put out $5,000 or $6,000, I don't have it to put out.
Right.
Well, there's other ways of getting the interest rates down, definitely. What were you being offered as a new interest rate on the refi?
3.8 something.
Yeah, see, and I could probably do a 2% on a HAMP, a home
Right.
affordable modification program, where instead of refinancing the first or the second, we actually go in and ask each lender, Citi and Wells Fargo, to modify the terms of the existing mortgages and get you as low as 2%.
And who cares who has first or second at that point, right?
Yeah.
I need to speak to you then.
Right.
Yeah.
Absolutely.
I mean, certainly we have to qualify, but credit score isn't involved.
Closing costs are not involved.
Closing, you don't have any closing costs involved, and it's just a matter of what is your gross monthly income. So, I mean, it's an hour consultation. We crunch some numbers together. I tell you whether or not I think you can qualify. I tell you whether or not there's any red flags as to, what might be a bump in the road to a qualification. But I meet a lot of people that I'm like, this is a no-brainer. You definitely qualify. It all depends, of course, on your gross income and a couple other things. I ask you to bring in a mortgage statement, ask you to bring in a most recent pay stub, or if you have a profit and loss statement for 2012, I look at that. And we sit down and I tell you what I think your options are. And if the option is, hey, maybe we need to go back to the title company, I'll tell you that too. But it's a free consultation. I'm happy to meet with you and do that. What area of town do you live in?
I live in Largo.
You live in Largo. Well, I will be in the St. Pete office all next week. So the number is 800.
Bear with me. I'm going to write it down.
Okay.
Okay, go ahead.
800-974-2712. And I will be in the St. Petersburg office. I will be in the Tampa office next week. You can call anytime. You can call the office now, 24/7. We've got people that can schedule you for a consultation. So if you want to come in, I'm happy to sit down and crunch some numbers and see what we can do.
I look forward to it.
All
I
right.
will definitely do that.
All right. Well, thanks
you
for
very
listening.
much for your time.
Thanks for listening to the show, and thanks for calling in. We appreciate it.
And same here. Thank you.
Thanks.
Bunch of great calls, Shay.
Yeah.
Yeah, 2 great calls back to back.
We do. And we have another one. We have Roy.
Hey, Roy.
Yes, hi, how you doing?
Good. How are you today?
Good. I got a question here. Like 5 years ago, my house they served me with a foreclosure.
Mm-hmm.
It actually got dismissed like a year and a half ago because Bank of America didn't show up to the court.
Right.
That's what Joseph
No.
needs.
Right. Exactly. That's exactly what he needs.
Now,
Could you switch cases with Joseph real quick?
One of the things that I did read on my foreclosure is that Bank of America stated that they either lost or misplaced my note.
Okay.
And
Love it.
that's something that I've been hanging on. I say, well, maybe there's a chance that I may keep my home. But now I'm getting letters from Ocwen. Ocwen is sending me letters where I can modify. They send me a letter of forbearance.
Oh, I bet they'd love to.
Oh, sure.
I bet they'd love to get you into a modified mortgage so that you can basically reaffirm the debt and they
Absolutely.
can have this new mortgage because they can't find the old one.
And a new statute of limitations started to run.
And now they're actually they're sending me letters for what I owe and what my new payments can be.
Mm-hmm.
And I'm under the impression, maybe I'm right. I went to go see a lot of different lawyers.
Mm-hmm.
Is there a statute of limitation after I get served with a foreclosure? I did hear the previous caller. I think that that you were talking about statute of limitations.
Oh, that's such a good topic to talk about. And you know what? We're going to take a break. And when we come back, we're going to focus on that statute of limitations because it's tricky. People love to think they can get a house for free, but it's not that easy.
Hold on to the phone there. You're listening to the Home Mortgage Law Show, 1-800-974-2712. 1-800-974-2712. That is a free consultation number. 1-800-974-2712. The law offices of Morse DuPont. More of the Home Mortgage Law Show right after this. You're listening to the Home Mortgage Law Show, brought to you by the law offices of Morris DuPont. Attorneys Will Morris, Shay DuPont, and Michelle Hanash, our bankruptcy attorney, here for you. It's toll free to call the show, 866-610-NEWS, 610-6397. AT&T Wireless customers, all you have to do is dial star 610. And we were on the phone with Roy.
Right. We had Roy on the phone, and Roy has a situation that is not too
Right.
uncommon.
Sure.
Right? Well,
Sure,
we see
absolutely.
this
See it
on
all
a
the time.
We see it on a regular basis. And that is that a foreclosure action was filed against his property. And within that foreclosure complaint was the information that the lender was acknowledging that they had lost or the note, or it was destroyed. They would have to sort of reconstitute
Right.
the note.
Reform. Right.
Reform the loan.
Right.
And in fact, that
There's a
foreclosure.
Reformation.
Thank you.
There you go.
So, in fact, that
Reaffirmation.
foreclosure action actually got dismissed by the lender.
Right.
And those kinds of foreclosures, when they had the lost note count, have been dismissed more and more over the last couple of years. So, Roy's question had to do with what happens to the statute of limitations after the foreclosure is dismissed. Now, we've got, at some point, Roy, you obviously missed payments on your
Right.
foreclosure, and I'm assuming that your lender sent you a notice of acceleration, that they were saying you've missed 3-4 mortgage
And you've
payments.
got 30 days to make good on it to cure the default. When did that happen?
That happened 5 years ago.
Okay. 5 years ago. Now, the statute of limitations is 5 years. Now, obviously, when the lender...
From what point?
From the time they sent the notice saying that, they're essentially giving you 30 days to cure, or they're going to accelerate the full balance, meaning they're not going to accept monthly payments anymore. You've got to pay off the full amount. All right?
Correct.
So you're saying that notice came to you about 5 years ago. Okay. So in the interim, they filed a foreclosure lawsuit, and obviously those 5 years stop running the minute they file a foreclosure lawsuit. Now, once the foreclosure lawsuit gets dismissed, it's as though a foreclosure lawsuit had never been filed. So the time for your statute of limitations starts running goes back to the initial default and notice of acceleration. So they have 5 years from that point to then file a brand new foreclosure lawsuit. If they fail to file it within that period of time, you've got a statute of limitations defense. Now, that statute of limitations defense can preclude the borrower from foreclosing on your property. Your lender, from foreclosing on your property or from pursuing you on the note itself. So even though they can't pursue you or the foreclosure, the lien on the property that's represented by the mortgage still remains.
Okay. So I can never get rid of the property, even if I win the statute of limitation.
Right. Even if you should prevail if they're beyond the statute of limitations period once they file the new foreclosure lawsuit. The fact that they cannot foreclose or sue you on the note doesn't remove the lien, the mortgage on the property.
What does remove the lien? Well, how
people
can you get the lien released, Will?
Well, some really creative people have thought of the idea of doing what's called a quiet title lawsuit. Now, the argument is, look, if the bank can't foreclose and if they can't sue you on the note, then this lien that's represented by the mortgage on the property is essentially putting an improper cloud on the title, and therefore the court should remove it. Well, the problem is with that is that a quiet title lawsuit is an equitable claim, and so is a foreclosure lawsuit, by the way. And courts sitting in equity, do not like the idea that somebody gets a windfall. So even though the bank can't foreclose on you on the property or can't sue on the note, I would be hard pressed to see somebody convincing a court to remove the lien from the property, remove the mortgage from the property, and thereby giving your house free and clear. Because remember, at some point, the bank did give you the money to buy that house.
All right, but Will, we have heard of some quiet title actions that have been successful where people then have the lien released from the house. How did they accomplish that?
Well, they were probably in a position like our last caller, Joseph, was in, when the whole file probably fell through the cracks. The bank doesn't respond to the quiet title lawsuit, and therefore the borrower is able to get a default judgment against them. And once that default judgment gets entered, then clearly they are entitled to get their property free and clear of the mortgage. But that doesn't happen very often.
Right. So they're not winning on the merits
They're
of the
not,
case.
Right. It's a technicality. It's a technicality where the banks, for some reason, whatever reason it was, doesn't respond to the quiet title lawsuit like you're supposed to under the law. If you don't respond within 20 days, then the opposing party has a right to go in and get a default judgment, and then ultimately a final judgment. But 9.5 times out of 10, the bank, actually 99.9999% of the time, the banks will respond to it, and they will respond to it by filing their brand new foreclosure action.
Now I got a question. Can Ocwen send me to foreclosure if they don't have the original? If Bank of America didn't have the original note?
Well, listen, they can. Listen,
Okay.
in the past, in the beginning when this whole foreclosure crisis started, every foreclosure lawsuit had, in connection with filing for a foreclosure, they filed a lost note count, right? And normally what happens at some point during the foreclosure lawsuit, even though there's this lost note count in the complaint, they finally show up with the original note and mortgage, and then this whole lost note count doesn't really matter. Even if they don't show up with the original note and mortgage, a court of law can still what's it called? Reformation. They can still reform the mortgage and say, well, even though you haven't lost, even though you don't have it, and you've established at some point you had it, and at some point you lost it, we're going to determine that you now have it and enter an order saying, we determine this copy that you have of the note to be the original, and then you're back to square one where they have the original note. Does that make sense?
Yes, and now for now I have the house the foreclosure got dismissed closer to 2 years ago.
Mm-hmm.
So right now they have another 3. Actually, they have less than 3 years to file the foreclosure.
No.
No?
You didn't listen to me. Listen, once the foreclosure gets dismissed, the statute of limitations goes back to before that original foreclosure was filed. The time they sent you the acceleration letter. It's as if that first foreclosure lawsuit was never filed.
Oh, perfect.
It's complicated, Will.
I know, it is complicated.
So that means that right now I'm past my...
You probably are. If you said it was 5 years ago, you probably are.
Okay, party at Roy's house. No, I'm only kidding.
You bringing the beers.
So this is a good example of why if you are thinking that you're going to default on your mortgage, if you are in default on your mortgage, it's so important to stay organized. You need to go to Office Depot, Office Max. You need to get a file folder and the key and the hole punch, and you need to keep super organized and hold on to every document that lender sends you, no matter what it is, because one of those pieces of paper that lender is going to send you after you go into default is hopefully
that acceleration letter,
that notice of acceleration, or sometimes headed notice of default.
Right. I mean, sometimes, look, even if they didn't send that letter out, if the mortgage itself contains an acceleration clause, from the time the seller, the lender, is able to send you a notice of acceleration, that is when the statute of limitations starts running.
And that's a very important date for anyone who is getting near that 5-year period to know, well, what is that exact date? Because I'm going to have to know that. So you're going to have to go back to your original mortgage and note documents, and you're going to be looking through the paperwork that you were sent from your lender in those first couple of months after you defaulted to look for that notice of acceleration. Because if you did receive it and it's been 5 years past that date and the lender tries to file a foreclosure action against you,
you've got a great argument against it.
Incredible defense.
Right.
And can they foreclose without sending that letter out?
You mean way back when you first defaulted?
Correct.
Well, there's an argument that the mortgage itself in paragraph 22 says, in most mortgages, says that the lender has to give you notice that they've accelerated the full balance, and that's a condition precedent to them filing a foreclosure lawsuit. Now, I've seen banks make several creative arguments against that, saying they don't necessarily have to send that notice, but you still have an ace in the hole. If the mortgage itself contains an acceleration clause, it doesn't matter whether or not they send that letter to you. That's when the statute of limitations starts running.
Correct. And so as far as Ocwen, I do not make any payments now. I am not going to send any trial payments that you're sending me now. I just wait to see if they send me to another foreclosure.
Well, back up, Roy. There's a lot implied in your question. I want to follow up on one thing that you said, Roy. You said, oh, so the lender can't file a foreclosure action against me under X, Y, and Z. Remember, your lender can always
file it.
They can always file it. It's what defenses you have to it. So after we get back from the break, we're going to go into what you could possibly do now.
You're listening to the Home Mortgage Law Show. Pick up the phone and book your free consultation with the experts, the law offices of Morris DuPont. 800-974-2712. 1-800-974-2712. More of the Home Mortgage Law Show right after this. And You're listening to the Home Mortgage Law Show, brought to you by the law offices of Morris DuPont. Toll free to call the show. Talk to the experts one-on-one. Now's your chance. 866-610-NEWS. 866-610-6397. AT&T Wireless customer star 610. Roy, welcome.
And we've been talking to Roy on the telephone. Roy has a foreclosure action that was dismissed against his property. It's coming up on 5 years since the time that he defaulted. He had some questions about statute of limitations, quiet title, what now, what can the lender do. But at the end of the conversation, Roy, we didn't really talk about what do you want to do with this property. Would you like to stay in this property? Are you interested in exiting the property? Do you have negative equity? Who's your lender?
Well, the lender originally was Bank of America.
Okay.
And, yes, I do want to stay in the property. And now Aquin is supposedly the servicer.
Okay. And last you heard, how much did you owe on this note?
$265.
Okay. And what's the current market value of the property?
$180.
Okay. So you've got a lot of negative equity on this property, and you probably have a lot of past due payments, possibly past due escrow, late payments, foreclosure fees from that one foreclosure. So it might even be more than $265,000. If Aquin said to you, we will reduce your mortgage principal balance to $200,000 and we will give it to you at 2% for the next 30 years, would you agree to that?
I'm very skeptical of that because in my mind, I'm thinking they probably can't take the house. So maybe I would, maybe I should take it. But because of the statute and all that, I'm wrong. I'm thinking that now that I'm talking to you guys, I may be wrong. It seems like a good deal at a 2%, but should I take that deal?
Well,
here's my thought on it.
All right, well.
Because you remember earlier I told you that even though they can't file a foreclosure lawsuit against the property or they can't come against you personally on the note, that the lien, which is represented by the mortgage, still remains on the property?
Oh, correct.
Okay. Now, if you ever in the future, assuming they can't do any of those things, and if you ever in the future look to sell that house, guess what you've got to satisfy before you can transfer proper title? You got to satisfy that existing mortgage, that existing lien on the property. And if I'm the bank, I'm looking at you going, you know what? You owed me $265, and before you can sell this property, you need to pay me $265. So in other words, unless you resolve that issue, you're going to be stuck in that house forever, ever.
So that might not be such a bad deal.
Right.
Or I can rent it out.
Exactly.
You could, sure.
Yeah.
So
okay, I don't know what to do at this point.
It's a tough call when you're in that situation. Some people have an ethical issue because they did borrow the money.
Right.
So they feel like, well, okay, I have during this time of hardship been able to stay in the property for 5 years without making a mortgage payment. But now my lender, Aquin, is reaching out to me, and it's quite possible that because they do know that there are some flaws in their case of foreclosure and they can't refile, that they're coming back to you and could possibly offer you a really, really good deal where, yes, you would be accepting that you, again, have to make payments on this, but the foreclosure action would be dismissed.
Right.
Think how quickly you could possibly pay off that mortgage if they were able to reduce it to $180,000. You'd be back in good stead with your lender. Your credit score would be able to have a chance to recover because right now it can't. It's going to stay depressed. So you've got a lot of things to weigh. There's not a right answer here.
But here's the other thing,
but at least I want you to understand that if Aquin is reaching out to you, look, come on in. I'll sit with you. I'll tell you if I think you can qualify for a loan modification based on your gross income and what kind of a deal I think Aquin should be offering you. And if we can do a loan modification and get that principal reduced, I think it's going to be a very enticing offer for you.
Yeah, it probably would be. It probably would be.
So,
I wouldn't mind going in there, sitting down with you, and crushing some numbers.
Well, here's my number to call. It's 800 974
974
2712.
2712.
Where are you located?
I live in Hialeah.
You live in Hialeah. Well, you can come and visit me at the Doral office.
Okay.
Right off of 87th Avenue and Northwest 13th Terrace, right there in in Doral. Love to see you. Give us a call at the office. There's always someone there if you want to schedule an appointment. Again, I'm going to be in the St. Petersburg and Tampa offices this week, but we've got Tampa, St. Petersburg, Dadeland, Doral, Fort Lauderdale, Aventura, Plantation, Boca Raton, and West Palm Beach. If you can hear our voice, there's typically an office nearby. And if there's not an office close enough, because I'm getting a lot of calls from Bradenton lately, and that's a long drive for people from Bradenton.
Like 2
so
hours?
I'm like, don't drive all the way. We'll do it on the phone. I'll tell you whether or not it's worthwhile. And we can crunch those numbers over the phone. So thanks so much for calling, Roy. I hope we've helped answer your questions, and we'll try to see what your different options are going forward in the free consultation.
Perfect. Thank you very much. Thank you.
All right. Thanks so much for calling the show.
Bunch of interesting calls, Shay.
Yeah, we have. We've had some really interesting calls today.
You know, I mean, I want to point something out to Roy.
Oh.
The downside of not doing this deal is that he has to be constantly vigilant that the borrower does not file a new foreclosure lawsuit against him, because even though the statute of limitation has expired, it doesn't say you can't file a lawsuit. And not unlike the Joseph who called before, whose case fell through the crack, God forbid Roy doesn't follow up on it, doesn't properly respond to that lawsuit, then the bank runs in and gets a judgment, and he's back to square one.
Okay, but let me ask you this. Let me be the devil's advocate, Will. Let's say that Roy doesn't do anything and the lender doesn't file a foreclosure action. And so at some point after the statute of limitations has clearly run, Roy files a quiet title action and he loses. The lender does respond and they don't agree to a quiet title action, but they can't foreclose on the property. Yeah. Oh, my God. Oh, so bad that there's a lien on the property. He's living there for free.
Right.
Like he said, he could rent out the property. The only thing is, if he ever tries to sell it, that he's going to have to satisfy that lien first.
Right.
So, yes, it's not part of his investment or retirement planning because he can't build any equity in this property. But if he but he is saving money because he doesn't have a housing expense.
Right. He can have a savings account or a retirement account
and
that can be his nest egg.
You expect me to have an argument against it? I have no arguments against that shit.
I'm weighing them both, and it could go.
It's up to how Roy wants to live his life. I mean, if he's fine with that, then he could very well do that.
Yeah, I mean, look. Yes, he borrowed the money, but it's up to the lender to move the case forward and to prove that they are the rightful owner of the note. Because if Bank of America says this is a lost note and the case had gone forward and Bank of America foreclosed on the property, and then 2 years later, here comes Wells Fargo saying, we're going to foreclose, and gee,
who are you again?
Who are you? And Wells Fargo goes, here, we've got the note.
Right.
What the hell is Bank of America doing with this property? We are the proper note holder. We are in possession of the note. So, the lender has to prove that they have the right to foreclose. They've got to show the note, or they've got to have testimony and affidavits that show it.
Listen, sometimes litigation is unforgiving, and litigation comes with inherent problems and pitfalls, and if you don't understand them, you can fall into them. And the fact of the matter is, if the bank doesn't pursue the lawsuit properly, gets their lawsuit dismissed, and then no file within the proper time frame within the statute of limitations, they're out of luck. I understand that, and that's their problem. However Roy wants to deal with it from here on out, I could tell him what the results of what his actions could be, but however he makes that call, it's up to him.
Yeah. No, it's a tough one.
Yeah.
So
I know what I would do.
Well, we did actually speak a lot about bankruptcy today, which is always delightful for me.
I wonder why.
But I think it's important to also remind the listeners about the debt settlement department and what we achieve there for clients who might not want to file a bankruptcy, or for whom bankruptcy might not be the best option. So we're able to work out usually a settlement through active negotiations to settle all types of debt. We do second mortgages, we do credit card debt, we do personal loans, and normally we're seeing an average settlement with the loans and with the credit card debt around 30 to 35%, and even lower with second mortgages. Shay, you know about this, around 10 to 15% we're seeing on unsecured second mortgages.
Michelle, My record on settling.
She's offended. She's highly offended.
Is 7.6
Excuse me.
cents
Well, I'm
on the
talking
dollar.
about averages.
Please get your
here.
figures right.
All right. Well, we'll continue this after the break.
You're listening to the Home Mortgage Law Show, brought to you by the law offices of Morris DuPont. Attorneys Will Morris, Shea DuPont, and Michelle Hanash, our bankruptcy attorney, will return right after this. In the meantime, pick up the phone and book your free consultation. 1-800-974-2712. 1-800-974-2712. More of the Home Mortgage Law Show right after this. You're listening to the Home Mortgage Law Show, brought to you by the law offices of Morris DuPont. Attorneys Will Morris, Shea DuPont, and Michelle Hanash, our bankruptcy attorney. If you haven't done so, make sure you log on to Facebook and like our page. It's the Home Mortgage Law Show, sponsored by Morris DuPont, PA. There's tons of information there going back to our website, our homemortgagelaw.com or morrisdupont.com. And frankly, there's just so much that we don't get to here on the show that's always posted on Facebook.
You know, it's difficult to really go in depth in some of these subjects. You know, just going over HAP today, the Home Assistance Program that the U.S. government has to help veterans. I mean, that's a really complicated program, and I'm happy to sit down with anyone who's interested in it. But I really need to do it in the consultation. It would take the whole 2-hour show to go through it. But really, we were talking about debt settlement.
And that's why we push the consultation. That's why we tell people to call us at the office.
Yeah.
Call the 800
Every
number.
situation is different.
Right.
Every situation is different. You can't hear another caller and say, "Oh, that's my situation." It turns out that
There's a little wrinkle, always a little wrinkle.
Yeah. But we were talking about debt settlement with our bankruptcy attorney here, Michelle Hanash, because her department also does debt settlement and credit restoration. But debt settlement, I have a question. Can you settle medical bills?
You absolutely can settle medical bills. We're settling many medical bills right now as we speak.
Okay.
And we were talking about our average percentage settlements. So as you corrected me, we have gone as low as 7%.
He was offended, actually.
7.6.
on an unsecured second mortgage. And in fact, I have even gone as low as 10% on an American Express settlement.
Whoa,
That's right. I remember that one.
Awesome.
But I like, what do we say? We like to underpromise and
over-deliver.
over. Exactly.
Yeah.
Sometimes, though, debt settlement might not be the right option for you. Sometimes you have more going on than unsecured debt or a unsecured second mortgage.
And you've also got to pay the settlement amount.
Well,
Right. You got to have the money to do it.
Exactly. You need funds in order to settle. Sometimes we can work out a long-term type of repayment plan, but that's going to be at a higher percentage. So why debt settlement might not be right for you and bankruptcy might be right for you? One, you don't have the money to pay a settlement.
Sure.
That's the number one issue. Two, you might need to get caught up on a mortgage. So maybe you have something else going on besides credit card bills, medical debt. Maybe we can strip a second mortgage from your property. That would be amazing. Maybe we need to stop a foreclosure. What can stop a foreclosure?
The filing of a bankruptcy.
Filing of a bankruptcy.
That's
Debt
one thing
settlement
to do.
isn't going to do that. And maybe you even have some older IRS debt. I'm just picking on some of the very few things a bankruptcy can do for you that debt settlement can't.
You can settle or you can discharge old IRS debt in a bankruptcy?
You can.
Really? I thought the IRS was exempt from discharge.
No, you thought wrong. There's so many things that most of our listeners probably don't know about that can be achieved in a bankruptcy. One of that is settling older, not even old, about 3 years old IRS debt can be settled. There's certain criteria that has to be met, but it can be a very amazing tool for someone who has extensive IRS debt. You can cram down not just on real property, but personal property. Your car, you might be able to cram down on your car and actually lower your interest rate.
What does the cram down concept mean?
Cram down concept means you can actually take the balance on what you owe on a secured loan and cram it down to the value of that property.
Lower the principal
the
balance.
principal balance.
So like if you have a car and you owe $15,000 and the car's only worth $7,000, in a bankruptcy you could cram it down to $7,000, and you're only responsible for paying the $7,000.
Exactly. And we can change interest rates when we do that. The same way we do it with real property. If you have investment property that's underwater, we can cram down your mortgage balance to the value of that property. As we spoke a bit about earlier, on your primary residence, we can strip completely unsecured liens. Second, third, HELOCs are included.
Home equity lines of credit.
Exactly. There are many, many tools available to you that can actually help you get going on the right path to clear up everything at once. So we're taking care of your unsecured debt, your mortgage, potentially your car, medical bills, all at the same time through the bankruptcy.
I think that if you look big picture, for anyone out there that's listening, if you are having trouble making your monthly mortgage payments, if you are overwhelmed with debt, if you have a job relocation and you need to get out of your property and it has negative equity on it, all of these issues that are associated with your property or your debt, you want to come to a law firm that can look at the big picture problem, not have on blinders, and not just meeting with all due respect, Michelle, a bankruptcy attorney, or with all due respect, Will, a foreclosure defense attorney. You want to you want to go to a law firm that can look at the big picture and say, look, this is how we could work this out in bankruptcy, and we would be solving problem A, B, and C. And this is how we could solve this through the use of foreclosure. And it will solve B, C, D, and E. And this is how we can do it through loss mitigation. And this will solve, well, it's loss mitigation. It's going to solve A to Z, darling. I mean, that's just the way we roll. But the point is you don't want to go to a law firm that only has one area or just is kind of doing foreclosure defense on the side, but they really do bankruptcy, because they're going to tell you that the only way to solve it is with a bankruptcy, and it's not true. But I don't want, as a loss mitigation attorney, to have someone walk in the door and they've got $60,000 in credit card debt and they have an IRS lien on their property and they have medical bills, and I'm trying to tell them that a loan modification is the best thing to solve their foreclosure. Because I'm going to say, you know what? Now that I know all of your big picture issues, I'd like Michelle Hanash to come in and also join us in this consultation, because I also want you to understand how bankruptcy could possibly kill 5 birds with one stone, where all I can do is solve your issues with your property. But Michelle can solve all of these issues that you have so that you can go on the road to financial recovery going forward. And Will is going to defend the foreclosure action, and we're going to be able to keep you in that house as long as possible. And hopefully we can get through the bankruptcy, these liens released, and so we can do a loan modification on the primary that's going to stay there. Big picture solutions to your big picture problems. We've got a couple of phone calls left. We're going to try and run through them real quick. If we can't get to your call, remember, you can call and schedule your free 1-hour consultation with anyone here in the law firm of Morris DuPont. The phone number is 800-974-2712. If you can hear our voice, there is an office nearby.
Sabrina, welcome to the show.
Hi, Sabrina.
Hey, thanks for taking my call.
Well, thanks for listening to the show. What can we do for you today?
Well, I have a couple questions. First off, I am a licensed realtor in the state of Florida. I have my appraiser's license, it's inactive, and I facilitate short sales as a listing agent. So I'm pretty familiar with principal balance reduction, loan modifications, and things like that. But I'm actually calling about my own personal situation. My husband and I, only he's on the note, we're being serviced by Bank of America. It's a non-amortizing loan, option arm. We took out the loan in 2004. For the first couple of years, we selected the minimum payment, made the payment. We had negative amortization for the first 3 years, so it's approximately $80,000. At year 4, we were no longer able to select a payment. It was mandated that you had to take whatever the payment was. I think it's $5,200. So, we're going through with the world, and we're thinking, well, it is what it is. We're negative am, but we're buying back our negative equity because interest rates are so low that part of our payment is going towards principal balance reduction, significant part, about $2,000 a month. Okay, so then fast forward last fall, I think, or early this year, I read about the scandal at UBS. My note is tied to the LIBOR. UBS traders in Singapore were manipulating the LIBOR, which
they sure were.
Change. I want to find a firm that can represent me to get my negative equity back based on the UBS manipulation of that LIBOR.
That is a major case.
Major.
And I would think that there would be some class action
I
lawsuits
would
that would
think
be
so.
involved.
Yeah, I've been on the web, I've been looking, because it's like, okay, my husband retires in January. In January, I can't afford the payment anymore.
Well, this is going to be a case that's outside of what we normally talk about on the Home Mortgage Law Show. So I am going to ask you to call the office, and you can speak directly to Will, and we can do a little bit of research to find out if
I'm pretty
it's
sure
so
it sounds-
expensive to
right,
do it on your
right.
own. I'd rather see you get into a class action
Absolutely.
lawsuit.
Yeah, I just haven't seen anything about it. I actually sent off a request to the Attorney General's office, Pam Bondi. I sent off a request to Treasury with the attorney that actually did the National Mortgage Settlement terms.
Well, those are good people to contact.
It
But
is.
again, it's so specific what you're asking about. Call us at the office.
Because think of the thousands of people. I'm not the only one. This happened to anybody that's tied to the LIBOR.
A classic case for class action.
Understood.
Yeah.
The number is 800
Yeah,
974
I'll give you guys a call.
2712. Thanks so much. Thanks for listening to the show. Thanks so much out there for listening. Another great week.
1-800-974-2712. That is the number to call to book your free consultation. Don't miss out on the opportunity. 1-800-974-2712. The Home Mortgage Law Show brought to you by the law offices of Morris DuPont. 1-800-974-2712. See you next Saturday.